Good morning, ladies and gentlemen. It's been a relatively short trial, and we've all seen how extremely attentive you've been. And I think I can speak for everyone in saying that we greatly appreciate that. Having said that, I'm going to call upon your patience one last time today as I review the evidence. I do promise I won't take a moment longer than I feel is necessary. But this is my last chance to speak with you. And there are a number of extremely important things I need to say before you retire for your deliberations. First, it's worth mentioning that I'm at a bit of a disadvantage because when I'm done, the prosecutor will come up and speak, and I can't come up again. This is the last you will hear from me. I won't be a long time leaving, but I'll be a long time gone. However much I may want to, I can't get back up here and refute anything that the prosecutor says to you during her closing argument. And so, as I review the evidence now, you may hear me anticipate some of her arguments. I'll do that because I hope that you'll think about how I would have responded had I had the chance to come up here and speak again. But there's a good reason I can't come back up here. There's a very good reason that the prosecutor gets the last word. And that reason is she has the burden of proving this entire thing. The defense doesn't have to prove anything, nothing at all. In our country, in America, it's the state who carries the burden of proving its case beyond a reasonable doubt. So that's why they get the last word. Now, ladies and gentlemen, it's important to remember that this case essentially relies upon a single question. One question. Who ran a red light causing the crash? The prosecution will argue to you that they've proven beyond a reasonable doubt that it was my client who ran the red light. They've presented various bits of evidence in an attempt to support that claim. The problem is that their evidence is unreliable and their claim is false. The truth is that my client did not run a red light. All of the evidence in this case points away from him being the one who ran the light and caused the crash. Still, ladies and gentlemen, there is something very important that I want to mention right at the start. Even if you believe that it is possible that my client was the cause of the accident, please bear in mind at all times the critical burden of proof that the prosecutor bears. She cannot merely prove to you that it's possible that my client ran the red light. She cannot even prove to you that my client is likely to have run the red light. None of these conclusions are sufficient under the law for her to prove her case beyond a reasonable doubt. We'll talk more about that critical standard of beyond a reasonable doubt, as well as the prosecutor's burden of proof in this closing statement. But I want to bring it up right away because it's so central to your decision. And it may give you a context within which to approach the evidence that both the prosecutor and I will discuss. Ladies and gentlemen, I'd like to begin by bringing your attention to the most important piece of evidence presented by the prosecution. In fact, this is the evidence that the prosecution relies on in order to claim that my client was the cause of the accident. That evidence is the videotape taken from the surveillance camera at Passaic School number 17, which appears to actually show the crash. Now, you've heard Detective Conroy tell you that this surveillance video shows that off-ramp of Route 21 onto Dayton Avenue. He also said that my client was traveling north on Dayton Avenue and ran through the traffic light. And as we learned during my cross-examination, Detective Conroy also set down these very same things in the report he wrote after his investigation. He says, it's all shown on the videotape. It's clear as a bell. You know, ladies and gentlemen, if it were that simple, we wouldn't be here. If it were really that obvious that that videotape showed what Detective Conroy thinks it showed, and what the state will argue that it shows, then we would have no reason to be here. There'd be no trial. But now that you've seen the tape, you know why we're here. But unfortunately, that tape doesn't show what the state claims it shows. It's not even close to true. It's not on that video. In fact, it's nearly impossible to tell what's on the video. So let's not just take Detective Conroy's word for it. Ladies and gentlemen, I would strongly urge you, when you retire to your deliberations, to review that video. And not just once, but many times. Many times. And when you do, you will see on that video what is not purported to be there by Detective Conroy. Now, what you may see is what you could interpret as a crash. Without knowing there was a crash, it would be impossible. But given that we know there was a crash in that area around that time, it's likely that what you see is a crash, and possibly the one involving my client and Mr. Fernandez. And you may also see an individual walking away from one of the cars. In fact, even though the camera is a significant distance from the site of the crash, you will be able to see the light coming from the traffic light. And at least at some point, you will notice that the light is green. But one of the many, many areas Detective Conroy is mistaken is in his assumption that the green light was directed at the cross street at the time of the crash. That would suggest that there was a red light at Dayton Avenue. But the video actually shows the opposite. It shows that there was a green light at the time of the crash, and it appears to be directed toward Dayton Avenue. That green light gave my client the right of way, allowing him to continue north on Dayton Avenue. Now, the truth is that it's all incredibly obscure. You can't really see anything very well on the video. It certainly does not show a car coming down the off-ramp from Route 21. It's not even clear that the off-ramp is even shown in the video. Even if it is there somewhere, the footage is simply too dark. It's too obscure for anyone to actually see anything clearly. So why is Detective Conroy so certain that it shows my client running a red light? The answer is simply because it fits perfectly with his preconceived notion of my client's guilt. We'll talk further about why Detective Conroy has this preconceived notion, but it is enough for now to just simply point out that it is absolutely impossible to see the car coming down the off-ramp of Route 21. The only thing the video appears to show is something resembling an actual crash. Now, if you look carefully at the video, the car going through the green light, and which appears to be in the crash, has moved through the light at around 13 seconds into the video. The crash occurs 3 to 5 seconds later. Now, I'm not suggesting that this is all perfectly clear. As I said before, it's virtually impossible to tell anything from that video, much less who caused the accident. But it is clear that one car on Dayton Avenue, which seems to be involved in a crash, went through a green light just seconds before the crash happened. To see that, you will have to look very carefully and multiple times at the video. But ladies and gentlemen, and this is very important, there is one thing that is not seen on that video. And that is a car stopped at a red light on Dayton Ave. This is critically important because this so-called eyewitness, Mr. Ruiz, has told us that he was stopped at the light and therefore supposedly had a perfect view of the crash. Of course, he never told the police officers on the morning of the crash, Nor did the police officers bother to take a statement from him and ask him exactly where he was when he saw the crash. But now, over 2 years later, for the very, very first time, he comes into court and he tells us that he was sitting right there at the red light on Dayton Ave. Ladies and gentlemen, although you can't see much from that video, if there were a car sitting there at the red light, it would certainly be visible. And yet it's not. It's not there because Mr. Ruiz is not there. Do you remember Detective Conroy showing you the video and pointing out what he claims was in that video? Do you remember one thing Detective Conroy did not point out? Mr. Ruiz's car. He never pointed it out. If it were there, and Ruiz was an eyewitness who saw the whole thing, Conroy would have shown you where Ruiz's car was. Perfect view. Not there. He didn't point it out because it just wasn't there. Had it actually been there, ladies and gentlemen, it would have been the very first thing Detective Conroy showed you. It would have been the very first thing he said. Here it is, ladies and gentlemen. Here's the eyewitness's car, located just where the eyewitness said he was, in a perfect position to see the crash. But you never once, not one blessed time, heard Detective Conroy say, here's the car. No one pointed out the car. Now, I know my ears are not pretty, but they work. I never heard anyone say that in this entire trial. I never heard anyone say, there is Mr. Ruiz's car, just like he told you it would be. Remember when I asked him on cross-examination, Mr. Ruiz, if there were a video of the crash, we'd be able to see your car, wouldn't we? And he said yes. There is a video of the crash. This car's not there. That's irrefutable. For some reason, and I don't know the reason, Mr. Ruiz is either lying or mistaken. But his car is not at that video sitting at the light. And this does raise an extremely important, in fact, troubling question as to why Mr. Ruiz tells us for the very first time that there was someone else in his car with him. This person in the car with him, presumably, would have had the exact same view of the accident that Mr. Ruiz had. He would have been sitting in the car at the red light, watching the exact same thing that Mr. Ruiz claims he saw. But astonishingly, no one ever spoke to this individual. Based on what Mr. Ruiz told us, this critical eyewitness was right there at the scene. And yet not one single police officer took a moment to speak with him. If such a person were there, this is not only atrocious, lazy, and unacceptable police work, but it deprives you, the jury, of knowing anything about what a critical eyewitness might have said. Because of police negligence or Mr. Ruiz's untruthfulness, we have no way of confirming whether or not the passenger's version supports this last-minute claim by Mr. Ruiz that he was just there sitting at the red light. Ladies and gentlemen, we are all aware of how dramatically the use of modern technology, including video surveillance cameras, has improved the ability of law enforcement to do its job. But, as we have seen here in this trial, it's often far from perfect. Had something occurred, the School 17 video would have clearly shown. But it's fair to say that this camera, located a tenth of a mile away from the crash location, and in the dark of night, is pretty much useless. It does very little to assist us in our search for the truth of what happened that morning. If anything, it shows a car, possibly my client's car, going through a green light and then crashing into another car that we can only infer did not stop for its own red light. But none of this is clear, and none of this presents us with an accurate view of what actually happened that morning. And so, given that there is no proof, no video proof of the state's accusation, they're forced to rely on the testimony of Edmund Ruiz. Now, you heard him testify here in court, and you'll have to assess his credibility. When you do that, when you assess his credibility, I would ask you to consider a few things. First, Mr. Ruiz is uncorroborated. There is no one else who sees what he claims he saw. No. According to him, there was someone else there, someone in his own car. But as we've discussed, the police simply didn't talk to that person. Ladies and gentlemen, it's also worth considering the degree to which Mr. Ruiz wants to be helpful to the police. He works as a security guard, in other words, a quasi-law enforcement job. Does he make up a story because he believes the police will like it? Does he exaggerate a story to fit the police narrative? We simply just don't know. But we do know that had the police done their job properly, we would have a better idea of Mr. Ruiz's motives and character, because there would be a written or videotaped statement in which we would have a far greater assessment and far greater details about who Mr. Ruiz is and what, if anything, he actually saw. But the police never interviewed. They never interviewed the eyewitness. That leaves us without being able to tell what he actually saw. Now, you've heard me talk about the taking of witness statements, so let me elaborate on that a bit. Taking a statement from Mr. Ruiz and his passenger, if there ever were such a passenger, is critically important. First, a sworn statement is a way of memorializing an individual's perceptions. When something is memorialized shortly after an event, it will not be necessary to wonder about the many ways in which an individual's memory may be affected years later. It's now been over 2 years since the crash, and for the very first time, Mr. Ruiz says he was stopped at a red light, and so was in the perfect position to observe what happened. What are we to make of this without the benefit of a police interview at the time of the crash or shortly thereafter? Ladies and gentlemen, it's always the case that when you have an eyewitness to any event, you want to know his or her point of view, their perspective. In other words, where exactly that person was situated relative to the thing or event that person observed. That's just simple common sense. And if you're a policeman or a detective who wants to get to the truth of what actually happened, and you have a witness who claims he saw something important, well then it's absolutely essential to ask him where he was. And yet even Mr. Ruiz testified. Even Mr. Ruiz said this to you, that the police never inquired as to his location at the time of the crash. Now, to be fair, the police at the scene of a crash can't always ask everything. In the rush of things, they may simply forget or not have time. But that is why it is so important. That's precisely the reason why it's so critical to take a sworn statement from any eyewitness. Taking that sworn statement gives the police officer or the detective an opportunity to put more thought into their questioning than might be possible at a hectic crime scene. And we can be absolutely certain that any experienced police officer or detective who was truly dedicated to getting to the truth would want to know exactly where Mr. Ruiz was located. That would be question number one. But because he never gave a sworn statement, and because the police officers at the scene neglected to ask him, the prosecution has to rely upon what Mr. Ruiz tells us 2 years later. Ladies and gentlemen, that is just simply not enough in a case this serious. There is no indication whatsoever on that videotape that any car was stopped at a red light. And so it was absolutely critical that whatever Mr. Ruiz had to say was memorialized as quickly as possible. But of course, it wasn't. And whose fault was that? And the very same thing is true for Mr. Ruiz's supposed passenger. If there were such a passenger, why didn't the police speak with him? Or is it possible they did speak to him and didn't like what he had to say? We'll never know the answer to that question because they claim to have no memory of him even being there. If he was at the scene, how could his presence not even come up? It simply defies common sense. If you're a police officer and you're investigating a crash and you have a witness who was in a nearby car, you would think that the very first question would be, was there anyone with you? Anyone else in your car? Furthermore, unless that person simply ran away, and there's no evidence of that, he would have been right there with Mr. Ruiz standing next to him. So, is Mr. Ruiz simply making all this up? Or was there actually a passenger there with the same view as he had? Did the cops simply miss him? Did the cops simply ignore him? We don't know, because the police didn't do their job. They didn't interview anyone. And so now, after 2 years, this is the very first time we are ever hearing anything about this critical second witness. In the end, we don't know what to make of any of this because this was a terrible investigation. This is not an indictment of all police officers. Every day there are police out there working hard to keep us safe and to find out the truth about the things that matter. But that simply did not happen in this case. Basic police work and basic common sense were abandoned that morning and in the days that followed. There is simply no justification whatsoever for the failure to memorialize the alleged observations of 2 alleged critical witnesses. That failure not only makes your job more difficult, but it raises serious questions about the propriety and the integrity of the entire investigation. Now, ladies and gentlemen, the prosecution's case is largely dependent on the idea that my client was intoxicated and that due to his being intoxicated, he was more likely to have run the red light. But that conclusion is completely contradicted by a careful examination of the evidence. Their main testimony in this regard is Officer Bordamonte's contention that he smelled alcohol. He later writes in his report, in which a number of boxes are checked, he suggests that my client was unstable, slurred his speech, and had other indicia of intoxication. But there are serious problems with his assessment. First, my client had just been in a serious car accident. Despite that, he had walked under his own power nearly half a mile before being apprehended by Officer Bordamonte in the area of the Walgreens drugstore on Dayton Ave. If, in fact, Officer Bordamonte had actually smelled alcohol, in light of the fact that he knew there had been a motor vehicle accident, it's absolutely inconceivable. It's inconceivable that he would not have performed the most rudimentary, the most basic field sobriety test to make that determination. It's routine. It's done all the time. When questioned about this, Officer Bordamonte claimed that he couldn't perform these tests because my client was injured and he needed to get him to the hospital. Ladies and gentlemen, that is complete and utter nonsense. That is absurd. That is insulting, and it's a lie. As we know, my client had already walked half a mile. At the time he was apprehended by Officer Bordamonte, it still took some time for the medical personnel to arrive. The fact is that there was absolutely no reason whatsoever why Officer Bordamonte could not have conducted some basic field tests had he truly smelled alcohol. Think about it, ladies and gentlemen. Could he have done a simple test of his motor skills by having my client touch his nose with his finger? That certainly would not have interfered with any attempt to get him medical aid. He could easily have had my client count backwards from 100 or recite the alphabet. Considering that my client had just walked about half a mile from the scene of the accident, it would not have in any way diminished his ability to get medical attention had Officer Bordamonte simply asked my client to stand on one foot to test his balance. He could easily have had him take several steps to see whether he could control his walking and whether or not he was truly intoxicated. We know that these and other rudimentary, basic tests are a tremendous help to police officers in determining whether or not someone is drunk. And they were simply not performed. And despite Officer Bordamonte's claim to the contrary, there was absolutely no rational justification for the failure to conduct very simple, basic tests. They should have been conducted, and they weren't. And that failure leaves us without critical knowledge, and knowledge that we would have seen with our own eyes from Officer Bordamonte's body camera. Despite this, Officer Bordamonte did make those notations on a form regarding alleged intoxication. But it's important to note, as I brought out on cross-examination, that those forms were filled out several hours later. In fact, they're actually typed where you can see the X's on the box where he decided to indicate. So for an example, he puts an X next to the word suggesting that my client had watery eyes or that they were bloodshot. He doesn't do this at the scene. He does this hours later. In fact, it isn't done until hours later at a time when Bordamonte knows that my client has declined to cooperate with the police. He declined to cooperate with the police because my client knew they were charging him with causing the accident, something he knew wasn't true. And what about Officer Bordamonte's body cam video showing us that my client was intoxicated? It doesn't. It doesn't at all. My client's speech was not slurred. The video of my client in the ambulance irrefutably shows my client clearly asking for his cell phone without any slurring of his speech. You never, in any video whatsoever, see my client's eyes bloodshot or watery. They have the video, ladies and gentlemen. All they had to do was point it at my client's face and say, "Hello, look over here, say something." They never did that. That's all they had to do. They're right next to my client the whole time. Aim it at his face, say, "Hi, you're on camera, smile." We would have seen his eyes. We would have seen everything that Officer Bordamonte puts down in the X's. But they don't do that. Had they done that, you would not only have heard his clear and unslurred response, but you would have seen his eyes as anything but bloodshot and watery. Do the police do that? Do they put the video in his face? No, they don't. Do they do that one simple thing that doesn't cost a penny or take more than 2 seconds? No, they don't. Do they do that one simple thing that would have wiped out any reasonable doubt? No, they don't. They never did. And you know the reason why. Knowing that the prosecution will argue that my client was intoxicated, we brought our own expert witness, Dr. Cohen, who has extensive experience with emergency medicine, which includes both traumatic head injuries as well as intoxication. He testified he has seen thousands of such cases in various emergency rooms for many years. The prosecutor, on her cross-examination, tried to discredit Dr. Cohen because he didn't have a long history of testifying in the courtroom. But ladies and gentlemen, that's exactly what we want. Nobody wants to hear from someone who has an extensive history of making a profit out of testifying in court. We want an educated, professional opinion, not one based on how much money you can make by testifying every chance you get, the kind of person who can be called a professional witness or a gun for hire. That's obviously not the case with Dr. Cohen, and therefore, his uncontested opinion warrants our serious consideration. And so we had him look at the body camera video of Officer Bartamonte and asked if he could see indicia of intoxication. He was emphatic that he could not. He did see an individual who had likely suffered at least some head injury after being in a car crash. He also testified that a head injury, such as that suffered by Mr. Hodges, could account for erratic behavior. In fact, we know that Mr. Hodges was actually walking home. Clearly, he wasn't thinking straight after the crash, given that he left his cell phone in the car. I asked Officer Bartamonte if Mr. Hodges looked like he was in a state of shock as a result of the crash. And Officer Bartamonte said no. But ladies and gentlemen, you be the judge of that. He was in a serious auto crash and began instinctually walking home. Is there any doubt that this crash had at least some effect on his ability to think straight? But as Dr. Cohen made clear, that is a long way from intoxication. But Dr. Cohen's testimony is also important with regard to a charge you will have to consider whether or not my client left the scene of an accident knowing or reasonably believing that someone else involved in the accident was in a helpless situation. The key element of that charge involves my client's state of mind. My client had been injured himself. His car ended up a long distance from Mr. Fernandez's car. There was no point after the accident that my client even saw Mr. Fernandez or Mr. Fernandez's car. He was undoubtedly dazed himself, but instinctively knew he was close to his home and so began walking in that direction. He had absolutely no idea that Mr. Fernandez was hurt or in need of assistance. There is no evidence presented in this case that even remotely demonstrates that he had any knowledge or reasonable belief that Mr. Fernandez was in a helpless situation when he headed toward his nearby home. And the prosecution must prove that my client had knowledge or reasonable belief, that my client knew or reasonably believed that Mr. Fernandez was helpless. It's clear from their own evidence he did not. Ladies and gentlemen, my client denied he caused this accident from the beginning. Do you recall what he said when Officer Bartamonte apprehended him? My client said, quote, "The motherfucker ran the red fucking light, so I hit him," close quote. He says similar things multiple times, even at the hospital when Officers Gerda and Bartamonte are present. And speaking of Gerda, he also comes in here at the last minute with things he subtly remembers years after the event. Things he, like everyone else in this case, failed to memorialize. He tells you that my client was angry about his car being damaged and that he recognized my client from high school. He also says my client told him that my client was at the Bonfire restaurant earlier on the night in question. But did Officer Gerda take the time to go to the Bonfire restaurant to see if anyone remembers my client there? No. Did he take the time to go to the Bonfire restaurant to see if anyone remembers if my client had been drinking? No. Of course not. Nor does Detective Conroy or anybody else follow up on this. More examples of an utterly inadequate, unprofessional, and lazy investigation. When I questioned Detective Gerda about whether he told anyone about these recent claims, he testified that he didn't have the authority to change Officer Bordamonte's report. But that's not even an answer. If he had additional information, there was nothing from preventing him from creating a supplemental report with that information. It also doesn't explain why we heard nothing about it from Detective Conroy, who, as the lead detective, has the responsibility of gathering together all of the information about the case and incorporating it into his report. But that's not how these policemen operated that morning or in the days that followed. They had an idea about what happened, a story that my client caused the accident, and that was good enough for them. They didn't need to do the natural common sense things like memorializing information, seeking out witnesses, or taking basic steps such as taking any number of rudimentary field tests to ensure that they got it right. Whether it was simply terrible police work or sheer laziness or both, it is impossible to know. But their investigation is hardly worth being called an investigation. These are extremely serious charges against my client, and those policemen had an obligation to do their jobs and try to get to the bottom of what happened. They didn't do their jobs, and that is the only reason neither you nor I can have anything but a reasonable doubt as to what happened that morning over 2 years ago. Now, ladies and gentlemen, none of this is to make light of Mr. Fernandez's terrible ordeal. The one thing we know is that he was injured as a result of this crash. And those injuries have caused him considerable suffering, and no one deserves that. But sympathy for him cannot be the basis for a finding of criminal guilt against my client. You must be guided by the evidence, regardless of how badly we may feel for Mr. Fernandez. Now, what do we know about Mr. Fernandez that morning? We know he was an Uber driver. And to his credit, he was also working another job. We know this accident took place around 4:47 in the morning. We know that at the time of the accident, Mr. Fernandez had been working for nearly 12 straight hours, with about an hour in between. Ladies and gentlemen, think he was tired? Think he may have been a little tired after 12 hours of work? Wouldn't anyone be tired? He's been working for nearly 12 straight hours, and we are to believe that it's not even reasonably possible that he made a mistake. It's not even reasonably possible that he was the one who ran the red light coming off the ramp and crashed into my client. That's what the prosecutor will tell you. They will say it's not reasonably possible. Their entire case is based on the idea that it has been proven beyond a reasonable doubt that it was my client and not Mr. Fernandez, a man who had been working for nearly 12 straight hours, who ran the light. They are sure of it. Their case doesn't leave room for even a reasonable doubt that it was their own witness, Mr. Fernandez, who, undoubtedly exhausted, perhaps sleepy, after a very long working day, was in fact the one who ran the red light. Ladies and gentlemen, their contention is absurd. In the end, with the limited evidence that we have, it is unlikely that anyone will ever know with absolute certainty who caused that crash. But there are some things we do know. We know that the video that was supposed to show us the crash and resolve these issues is, for the most part, useless. That video tells us virtually nothing about what happened. We know that the police conducted a terrible investigation. They failed to take a sworn statement from one single person in this case. That is simply inexcusable. It is standard police practice to memorialize what a witness has to say so that we are not reliant on faulty memories years after the fact, as we are now. We also know that Mr. Ruiz says there was another person in his car. If that's true, then how was that missed by the police? It's pretty much inconceivable that there would be another eyewitness right there and absolutely nobody knows anything about him or her. How is that possible in a properly conducted investigation? The truth is that it's not. Unless, of course, Mr. Ruiz is lying about it. Is that a possibility? Well, we know that Mr. Ruiz testified he was sitting at the red light on Dayton Ave at the time of the crash. A fact he conveniently failed to tell Officer Bordamonte that very morning, and only now tells us 2 years later. We also know there is no car parked at any red light in the video. We know that Detective Conroy never pointed to any such car when he played the video. No one will ever know if Mr. Ruiz is lying, telling the truth, exaggerating, or just mistaken. But we do know now, as I said in my opening statement, that there are, in fact, a mass of critical inconsistencies, glaring omissions, and too many problems with this story for it to stand as the principal ground upon which to convict my client. The testimony is simply not reliable. In the criminal law, as you have heard, and we'll hear again from the judge, guilt must be proven beyond a reasonable doubt. That is the highest standard of proof in the law. But the evidence presented by the prosecution cannot stand up even to the slightest scrutiny. So how can it be relied upon in order to make a determination that requires there be no doubt based in reason? The answer is simple. It cannot. And as a result, ladies and gentlemen, the state's evidence, arising out of a tremendously flawed investigation, does not assist us in our search for the truth. On the contrary, it raises far more questions than for which it provides answers. It paints a picture of events that is far more obscure than it is illuminating. Daylight never exposed such a clouded and misperceived swell of accusations. And there's a tremendous danger in that. There's a tremendous danger that a lack of evidence can lead us down a road of speculation. That should never happen in a criminal case. A verdict cannot be based on speculation. Sometimes, in the absence of facts, it's easy to imagine something happening, or it's tempting to think it could have happened a certain way, or might have happened in a certain way, or even that it's likely to have happened in a certain way. But that type of thinking is nothing more than mere speculation, and it should never take the place of evidence rising to the standard of beyond a reasonable doubt. What evidence does the state have against Mr. Hodges, ladies and gentlemen? A video that is too dark and too far away to really see anything of value. A witness whose claims are refuted by what little we can actually see from the video. And another witness who simply vanished into the ether, if he even existed. Ladies and gentlemen, that's it. There's no more evidence against my client. So how can a case be built against him? Merely upon speculation. There is simply nothing, no facts whatsoever, no evidence at all that can stand up to this slightest scrutiny. This case that looked so strong when the prosecutor gave her opening statement has been exposed for what it really is. A case that is built on nothing upon which you can rely. Ladies and gentlemen, when you go back into the jury room to deliberate, I'd like to ask yourselves a simple question. What other decision in life would you make and feel confident in based upon the degree of trustworthiness of the evidence we've heard in this trial? Would you make any decision at all based upon this kind of evidence? Would you buy a used car based upon the trustworthiness of this evidence? Would you put a mortgage down on a house based on this kind of evidence? I submit to you, ladies and gentlemen, that you would not make any important decision whatsoever based on the kind of evidence we've heard in this courtroom. How could you? What confidence could anybody have in the veracity, the truthfulness of it? And yet, the prosecution wants you to make the most important decision imaginable. A truly momentous decision, one that affects the life and freedom of my client. They want you to make a decision to find him guilty of an extremely serious crime and to make that decision based upon evidence that you wouldn't find trustworthy enough to make any other important decision in your life. Ladies and gentlemen, let's talk just for a moment about that burden of proof. It may be the single most important legal principle in any criminal trial. The prosecution has the burden of proof, and the defense doesn't have to prove a single thing. And yet, I think it's fair to say that in this case, the defense actually has proven that my client is not guilty of these charges. Every piece of evidence presented by the prosecution has been discredited or rendered meaningless. But let's just say for argument's sake, let's ask ourselves, not whether Mr. Hodges recklessly ran a red light and caused this crash, but only whether it's reasonably possible that he didn't. If we answer honestly, it may seem absurdly obvious. But yes, of course, it's reasonably possible that my client did not cause the crash. The question is it reasonably possible that my client did not cause the crash? Now remember, I'm not asking you whether you're certain he didn't cause it. I'm not asking if you're firmly convinced he did not cause it. I'm not even asking you if you think it's probable that he did not cause the accident. I'm only asking if you believe that there's a reasonable possibility he didn't cause it. I'm asking you if you believe that there's a reasonable possibility Mr. Hodges did not cause that accident. That, ladies and gentlemen, is the single most important question in this case. And I would ask you, when you go back into the jury room, to ask yourselves, is there a reasonable possibility that Mr. Fernandez, after nearly 12 straight hours of work, was the one who actually ran a red light and caused this accident? That is such a critical question, because if the answer to that question is yes, that it's reasonably possible Mr. Fernandez, rather than Mr. Hodges, ran the red light, then, ladies and gentlemen, that is reasonable doubt. That alone, the existence of a reasonable possibility that my client did not run the red light, that he did not cause the crash, that alone, that reasonable possibility, means that the state has not met its high burden of proof, and the verdict must be not guilty. Ladies and gentlemen, there's a very good reason for that high burden of proof. We have here a difficult situation. We would all be less than human if we were not tempted to allow a bit of passion to seep into our desire for justice. But just as there is a desire for justice, we cannot dispense it if it means creating another injustice. The evidence shows that my client did not commit this crime. He should not be sacrificed because we want justice for the injuries suffered by Mr. Fernandez. My client's life has meaning too, and it should not be destroyed simply because we understandably feel badly that Mr. Fernandez was injured. Ladies and gentlemen, we are not here to decide whether or not something bad happened. We all know that it did. You must search for reasonable doubt, which, as I have said, could mean a reasonable possibility that Mr. Hodges did not cause the crash. Ladies and gentlemen, we all selected you because we had a sense about you, a belief that you would follow the law and carefully evaluate all of the evidence. And that's what I ask of you. Review all of the evidence. Listen to each other. Hold these questions up to the light of your own common sense and ask yourselves, is this the kind of evidence upon which I can rely? Is this the kind of evidence I can trust in order to convict a man, an innocent man, of a very serious criminal charge? Is there a reasonable possibility that Mr. Hodges did not run the red light? When you're done with that review, that question, I feel sure you will come back in here and give us a true verdict. One in which you say simply that the state did not meet its burden. It didn't meet its high burden of proving my client's guilt beyond a reasonable doubt. Ladies and gentlemen, they did not prove it. They didn't even come close to proving it. And I'm confident that you will find that the only truthful verdict here for my client is not guilty. Thank you.
All right, thank you. We'll take a 10-minute break at this time. And we'll come here closing arguments. Okay, so if you just turn to the jury room, the call for you fairly soon.